Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today, and it's in its 5th season. The webinar, I know, Tom, I know. and the surprising title is Most Important eDiscovery Case Law Decisions for June of 2025 with our faculty experts, Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We welcome your questions and feedback in the council. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as will all of our EDRM webinars. And slides will be available after the webinar as well. Kaylee Walsad, EDRM's Chief Strategy Officer, is here. Kaylee, can you please tell us what resources are available?
Absolutely, as long as you can hear me, Mary.
You know I can, or maybe you don't.
Well, we are loving On24 with so many more ways for you, our audience, to engage. If you check out your console to the right of your screen, you'll see the question mark icon. And if you click on it, this is where you can type in your questions for today's faculty, and we highly encourage you to do so. If you click the paperclip icon, this is for related content. You'll see, once you click on it, today's resources carefully curated just for you. There's an On24 engagement tools description for you to download to help you better engage with the platform. You can click the link to subscribe to eDiscovery Today's blog and never miss a thing. It's my favorite way to start the day, and I highly encourage you, if you're not subscribed, to do so. There's also a link to learn more about our beloved Honorable Judge Peck and how you can engage with him. There's also a link to order your copy of Tom O'Connor's spicy book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's important eDiscovery case law decisions for July, which I did laugh, Mary, when you said, and the surprising title is 5 years of the same title, different month. So that July case law will be held on August 5th. So be sure to save your seat and don't miss out. And then up next on EDRM's webinar channel, July 10th, evaluating legal tech vendors, what legal teams need to know. Be sure to save your seat for that great discussion. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, you'll see the smiley face emoji in your console. If you click on it, it'll pop up many more reactions that you can click on during the webinar. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And then the Twitter bird is for social media, where you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And our faculty today, we have Doug Austin, as always, anchoring. He is the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices in case law that is celebrating its 5th anniversary as well. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published his daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Super Reader's Choice Award as a top eDiscovery author and top cybersecurity author. Doug has presented at numerous webcasts, events, and conferences, including Legal Tech New York, ILTACon, Relativity Fest, University of Florida eDiscovery Conference, the Masters Conference, and many local and regional conferences. With him, we have Tom O'Connor, who is the director of the Gulf Coast Legal Technology Center. Tom O is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. His most recent edition of his popular book, eDiscovery for the Rest of Us, was launched earlier last year, I believe, with EDRM's trusted partner, NextPoint. And Tom also hosts with Rocky Messing the wonderful eDiscovery channel on YouTube. And our beloved Honorable Judge Andrew Peck is once again a Band 1 Chambers ranked senior counsel at DLA Piper. Congratulations, Judge.
Thank you.
And Judge Peck has served for he served prior for 23 years as a United States Magistrate Judge for the Southern District of New York. And before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA Piper, Judge Peck advises on those copyright and trademark matters, but also serves as a resource for the firm and its clients on litigation strategy and e-discovery issues from a judge's perspective. Judge Peck particularly advises on innovative and efficient solutions to the challenges of information management, both within and outside the litigation context, including cross-border discovery issues. He frequently speaks at conferences concerning these same issues, and since joining DLA Piper, Judge Peck has been retained to serve as special discovery counsel to clients and law firms, and to submit expert reports on e-discovery issues. EDRM is grateful to all three gentlemen for their service on our Global Advisory Council. And without further ado, Doug, do we have some cases?
We have a few, Mary, welcome everybody to our June case law webinar on the EDRM network. Yes, we do indeed have another 6 cases to discuss this month, and these cases address disputes related to court-decided ESI orders, supporting sanction to submit a Jackson affidavit, evidence for experts, unprofessional behavior by counsel, production of likely responsive tar hits, and dispute over emails and Microsoft Teams messages. Of course, we do welcome questions, and we'll try to get to as many as we can, and we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That's especially true if we use strong profanity in the making of this webinar.
Oh, darn.
Ouch. Yes, and some of you will see what I mean by that in a while. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, formerly known as eDiscovery Assistant, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and e-discovery terms. Minerva 26 has over 42,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for e-discovery case law out there. So with that said, let's get into the cases. In this instant putative class action, which was previously covered by Michael Berman on his eDiscovery LLC blog concerning alleged excessive force and failure to address misconduct by the city of Rochester, plaintiffs and the city defendants tried to develop an ESI protocol they could both agree to, but they were unable to do so. After continued failure to agree, Magistrate Judge Mark Peterson directed the parties to submit proposed protocols to the court. He told them if they submitted proposed protocols, he would review them and pick and choose the items to put in the final ESI protocol, which would become the ESI order for this action. When they were still unable to agree, Judge Peterson then issued the ESI order based on the parties' proposed orders. The city defendants timely filed objections to the ESI order, arguing that the ESI order must be vacated in its entirety as it suffered from several errors. Spoiler alert, New York District Judge Frank Gerasi overruled the city defendant's objections to the ESI order, including those that argued that the ESI order violated Local Rule of Civil Procedure 26E4. His ruling on those objections included good cause, where he said, as required by Local Rule 26E4, plaintiffs made a motion to the court to compel the production of metadata and to enter plaintiff's ESI protocol, arguing that there is good cause to require the production of metadata in this case. Plaintiffs argue that workflow history and metadata from the use of force reports, civilian complaints, and internal investigation files are critical to their claims of excessive force and failure to supervise and discipline. Here, plaintiffs have explained that the information they seek cannot be obtained from sources like the text of the requested documents because they seek to verify that the text of the documents accurately reflects what happened and accurately conveys if there were any revisions. As such, this court believes that plaintiffs have shown good cause to require the production of metadata. Regarding search terms, he said, the court disagrees with the city defendants that plaintiffs must identify search terms or reasonable restrictions upon searches to demonstrate a particularized need. He also rejected the argument from the city defendants that Judge Peterson failed to consider that they do not have the technical ability to bait stamp or redact items produced in native format to comply with the ESI order, stating the ESI order does not require bait stamping of native files. As for redactions, while the ESI order calls for redactions of native files, it also explains that if files produced in native format require redaction, the parties may discuss producing redacted versions in PDF format as an alternative. And he also rejected the argument from the city defendants that Judge Peterson erred by ordering that production be compatible with plaintiff's ESI program relativity, as you see there. Judge Gerasi ruled the same way in other arguments, and you can check out the case to see those. So, Tom, the city defendants balked over things like not having the technical ability to bait stamp or redact items produced in native format and producing in a relativity compatible format. Do you think their objections are tied to a lack of understanding of basic eDiscovery best practices?
Well, I wish it rose to that level, but I think that first, I think it shows a lack of understanding of basic technology practices. Those sorts of objections, particularly, oh, we can't bait stamp native documents and we can't redact it. Those have become like the modern boilerplate language of ESI productions, and they appear, I see them over and over again, which tells me that the parties are, well, it's boilerplate. They're just cranking out those objections when, in fact, there are technical solutions available to deal with those problems. But above and beyond that, in this case, it seems like they didn't seem to have read the ESI order very closely. The judge pointed out several times, as you stated, well, first, the ESI order does not require bait stamping of native files. So you're objecting to something that I didn't order. And when it came to redaction, he again, as you pointed out, had a procedure that they could follow. There's an alternative that you should discuss producing in PDF as an alternative. And what he went on to say, which was, I think, even more telling, was that, quote, if the forms of production allowed by this protocol present an undue burden or cost for the producing entity, the parties shall meet and confer to try to agree on a reasonable alternative form of production, end quote. And he went on to say, quote, native production will be determined on a case-by-case basis, end quote. So meet and confer and talk about individual documents. Don't make blanket objections as you have here. So it's a little distressing that the parties seem to use, again, I'll say it again, a boilerplate language to object to things when the judge had given them a clear path for how to deal with those issues.
Yeah, absolutely. It seems like they failed to acknowledge that there was a lot more flexibility in that ESI order than they gave it credit for. No doubt about it. So, Judge Peck, given the parties couldn't come to an agreement on the ESI protocol, do you agree with the decision by Judge Peterson to select the items for the parties? And do you agree with him issuing an ESI order based on those selections?
Well, I am not a big fan of ESI protocols, particularly protocols that then become a court order. but we don't have time to go through all the reasons behind that. I know that some judges, and I'm not throwing somebody under the bus here, but my good friend Xavier Rodriguez from the Western District of Texas, he and I have been on enough panels together that I know that if parties came to him with the request that they made to Judge Peterson, please choose which provisions to put in this, he would have told them to go away and either work it out or only enter in the protocol those things they agreed on. Having said that, I probably, if I were still on the bench, would have done what Judge Peterson did and said, okay, you've agreed on all of this, but on some of the requests, there's the plaintiff's proposal versus the defendant's, and would have picked the ones or modified and not taken either in order to make it a reasonable order. I do think there is something a little bit unseemly about going to the judge and saying, please pick from ours or theirs. And then when you don't like the way that picking went, taking objections up to the district judge.
Unseemly.
Indeed.
Good
Unseemly.
word. Yeah.
All right. Yes, I like that. Indeed. And obviously it didn't work out for them. So Mary, we talk a lot about federal rules, but local rules drive discovery too, as they did in this case. So what advice do you have for our audience on how to balance the requirements of both federal and local rules in discovery?
Well, certainly you've got to be up on your federal rules, because those cover, the national scene, but you're going to be in front of a particular jurist in a particular courtroom in a particular city or state. And there you may want to look at their website, the court website itself, for some local rules, but especially for the jurists themselves, they may have some preferences about things like length of filings, requirements for in-person 26Fs. Maybe they can save some time getting things resolved in more informal ways. Even things like line spacing or fonts and things like that. You don't want to invoke 1.1 rule. Inadvertently by tripping over a local rule requirement. And the federal rules, they're in the process of being changed all the time. uscourts.gov is a great website. They have PDFs that usually are like 400 pages or whatever on all the various rules and whatnot. But it's a great site to bookmark.
Yeah, absolutely. Go ahead.
Let me just jump in and supplement here. The federal rules are the rules if you're in federal court, period. No discussion needed. Local rules are district-wide. They have to be put out for public comment before they are enacted or modified. And they also have to be approved by the relevant circuit in which that district court exists. And those local rules are just as much rules as the federal rules. It's not an option to ignore them. Then various judges have their own chambers practices, chamber rules, whatever you want to call it. And I agree with what Mary said. You don't comply with those at your risk. So read the rules.
Or as Tom would say, because Tom, yes, Tom, I want to steal the line for you read it. You say it. Read the rule book, Shankopotamus.
There you go. All right. Yes, absolutely.
The other one, for those who've been around long enough to remember our friend Chris Dale.
Oh, you're going to do it.
he had this, RFR rather, which is read the federal rules. Now they don't have federal rules in England. So the extra F in there, read the friggin' rules.
Indeed. Yes. That's always good advice and good practice. So let's move on to our next case. and this case involved wage disputes, and the plaintiff sought relief against two sets of defendants, the Thai Greenleaf defendants and the Greenleaf defendants. The court had initially ordered the production of contact information for all non-exempt employees employed after March 16, 2018, in support of conditional certification for a collective action under the Fair Labor Standards Act. While some effort was made by the Greenleaf defendants to supplement this information, what was eventually produced fell short. A list of 10 names was provided, but without essential data such as phone numbers, email addresses, or employment dates. For the Thai Greenleaf defendants, the situation was worse. They produced nothing of value. When pressed, their attorney claimed they had no additional information and failed to produce any sort of affidavit or explanation by the court's March 14 deadline. To compel compliance or clarify the absence of records, the court ordered the defendants to either provide the outstanding documents or submit Jackson affidavits by that March deadline. The Thai Greenleaf defendants, however, failed to provide any such affidavit, though their counsel, John Stevie, stated they would. Still, New York Magistrate Judge James Wicks stated the court is extremely skeptical of this assurance in light of the recent noncompliance with the court's directive to produce a Jackson affidavit and lack of explanation for Mr. Stevie why one has not been submitted to date. The Greenleaf defendants did somewhat better, delivering a Jackson-style affidavit and certain bank records on the morning of oral argument, and Judge Wicks noted that plaintiff's counsel agreed that the affidavit was satisfactory. Still, he said, despite having an opportunity to do so in their opposition papers to plaintiff's sanctions motion, both defendants failed to comply with the undersigned's directive to submit a Jackson affidavit by a date certain. The time for compliance has come and gone. The undersigned now proceeds to analyze whether the imposition of sanctions requested by plaintiffs is appropriate under the circumstances. For the Thai Greenleaf defendants, Judge Wicks stated, by Mr. Stevie's assertion that no further information is in defendant's possession, he effectively concedes that the Thai Greenleaf defendants failed to maintain the requisite information demanded by the relevant regulations. Consequently, the sanction of publication of notice at Thai Greenleaf defendants' expense is a proper sanction under the circumstances. So Judge Wicks ordered them to bear the cost of both print and online publication of the FLSA notice to potential collective members. For the Greenleaf defendants, Judge Wicks carefully applied the relevant Patterson four-factor test described in the case and ruled, after weighing the Patterson factors, the court concludes that the Greenleaf defendants are precluded from offering as evidence at trial any of the documents previously requested or demanded but not produced on the issue of successor liability. He did exclude the documents the Greenleaf defendants produced at oral argument from that preclusion order. So, Judge Peck, we've covered many cases where parties failed to produce documents, yet we haven't seen them ordered to produce a Jackson affidavit. What is a Jackson affidavit, and when is it warranted when parties fail to meet their production obligations?
Frankly, I never heard of a quote-unquote Jackson affidavit.
Okay, it's not just me.
Till we got to this case. Now, as with many, such labeled things, it comes from a particular case involving a Mr., Ms., or whatever. Jackson. It was a New York State court decision. It's discussed in footnote 6 of Judge Wicks' decision. It's like other doctrines that derive from a case name. An Allen charge to a deadlocked jury, the so-called dynamite charge, came from a case involving a Mr. Allen. Miranda warnings, which by now have become, known to everybody, and the source of law and order shows and all of that, came from Miranda against Arizona. But what it is, as Judge Wicks explained, is something that details the good faith efforts to obtain the requested documents, explaining where the documents likely were, what efforts were made to preserve them, and whether they were routinely destroyed or whether a search was conducted in every location they likely were. Maybe a bit excessive, but it is a way to get that information, which is likely to be, the affidavit is likely to come from counsel, not from a party, because counsel is the one running the discovery process, or at least as we know from cases, it's supposed to be counsel and not the client doing their discovery.
Yeah, that's it's interesting. I certainly hadn't heard of it, so I feel a little bit better that you hadn't heard of it either. So interesting. There was one of the things I noticed about this case that I thought was unique. So Mary, do you think that the cost of both print and online publication of the FLSA notice to potential collective members was a significant enough sanction to the Thai Greenleaf defendants when they didn't ever produce a Jackson affidavit?
Well, I think it's so difficult these days to get any kind of sanction that, having the sanction basically puts a marker down for the next time if it's needed. And certainly they had to pay something. They have a reputational cost, externally as well as with the court. It's online publication as well. They may see an increase in the collective members.
Yes, I would think so, and probably should. So that will be interesting. So Tom, Judge Wicks denied plaintiff's request for monetary sanctions because they failed to include it in their motion as Local Rule 7.1A1 requires. They only mentioned it in the hearing. Was that a failure on their part?
Well, yeah.
All right.
We just talked about this, and I mentioned it, but I thought Mary and Judge Peck talked about, paying attention to the rules and what it mean for your practice. For example, if it was in the local rules, then you should have done it. I wonder if it was just an oversight, like somebody just dropped the ball. But I always tell any clients I advise when I'm giving presentations, whatever, I tell everybody, look at the general, look at the FRCP, but as Judge Peck said, the local rules are equally in play, and you've got to make yourself aware of those. This is a good example of what happens when you don't.
Yeah. Couldn't agree more. So our first couple of cases emphasize the importance of the local rules, and we'll move on to our next case. And I mean, let's face it, in many of our cases, the parties have a real beef with each other, but not in this case because it's between makers of meatless products. Thank you. The plaintiff disclosed an expert report by Dr. Thomas Marinick. I'm just going to keep on going. Who stated that plaintiff had retained him to design and conduct an online survey assessing consumers' likelihood of confusions as to the slogans. During his deposition, Dr. Marinick revealed that he had carried out 2 pilot surveys, but discarded both pilot surveys because of issues with the first and results that didn't make any sense with the second. Only the results from the final survey were included in his report. Defendant Beyond filed a motion to compel the results of the 2 pilot surveys. In discussing 2010 amendments to the rules that address the potential conflict between expert disclosures and work product protection, Massachusetts District Judge Indira Talwani, noting that the 2010 amendments made this correction with 2 sets of changes that are relevant here, stated, Rule 26 protection of drafts is designed to protect attorney work product. The rationale for protecting attorneys through the work product doctrine does not extend to testifying expert witnesses who play a fundamentally different role in litigation. Second, the requirement for the written report in Rule 26A2B was amended to provide that disclosure include all facts or data considered by the witness informing the opinions to be offered rather than the data or other information disclosure prescribed previously. In considering Vegadelphia's argument that the pilot surveys could not have been considered by Dr. Marinick because they were discontinued, and he formulated his likelihood of confusion opinion solely on the basis of the final full survey, Judge Talwani stated, Robocast Inc. v. Apple Inc. is instructive. There, the the District of Delaware found it difficult, if not impossible, to believe that an expert whose opinions are predicated upon the creation of a statistically meaningful effort could have, in the statistical sense, completely ignored the data that had been previously collected by him, even where the data from prior surveys had been deleted and the expert attested he could no longer remember them at the time he drafted his reports. When an initial survey is fine-tuned by adjustments, although the statistician may eventually ignore or forget what happened with the initial survey, he has by definition relied upon the first survey to formulate the subsequent survey. The former is effectively a stepping stone. That is, the expert is as informed by what answers the questions provoke as by any perception that sample size may be insufficient or that the questions themselves must be altered in some respect. Dr. Marinick designed the final survey by moving from a video to still images and by modifying stimuli to avoid the deficiencies he encountered in the pilot surveys. He remembered the pilot surveys and his modifications when testifying about them at his deposition. The court finds that he did consider those pilot surveys and their results in formulating his final survey. Accordingly, the court finds that the pilot surveys and their results are facts or data considered by Dr. Marinick that should have been disclosed in his expert report. So she ruled that the expert's pilot surveys must be produced. Perhaps the parties could have avoided this dispute with a meet and confer. So, Mary, if this case had happened before the 2010 amendments, do you think that Judge Talwani would have ruled the same way?
Well, when you have the testifying expert, doing some studies before the things that the expert's going to rely on, it's entirely possible he would have ruled the same way. Back then, we used to split consulting experts and testifying experts so that the consulting expert would be free to give all sorts of opinions that or data or whatever it is, advice, without the threat of needing to testify about that. And that was not an absolute, that they wouldn't have to testify. But since it was the same person, probably. I'm interested in what other people think. I think that he might have been ordered to produce those things.
Well, certainly one thing that factored in was his mentioning the pilot surveys in the deposition. So, Tom, given that he did that, and that led to the defendants discovering the existence of them, what do you think about that? And what advice do you have for our audience on how to prepare for a deposition to minimize the chances of unwanted disclosures?
Well, I think you need to take into account what the judge said in your second paragraph up there, that the rationale first for the privilege is to protect the work of the attorneys and not that of the testifying witness. And as I think Mary pointed out in our first case, you got to be aware these rules change. I wonder if perhaps the attorneys maybe were thinking of the old standard when they were prepping their witness in this, and hadn't considered the fact that the rule had been amended, as the judge pointed out in that paragraph. So you got to make sure that you sit down and go over everything. I take Mary's comment about the old distinction between consulting and testifying witnesses as something that was a standard practice, and I wonder if they somehow inadvertently fell into that trap and thought they didn't have to worry about those old reports. You got to make sure you're aware of what the standards are under the rules as amendments pop up, and have that sort of discussion with your witness.
Yeah, absolutely. And one of our audience members notes that as this seems to be delving into cognitive science and whether or not previous knowledge affects later conclusions, which I think is certainly a valid point. So Judge Peck.
I'm sorry, just to interrupt real quick. I think as I read it, the witness said originally he didn't recall, but that somehow those facts did influence what he finally did. So I think that opened the door to it.
Yeah, certainly did. So Judge Peck, one thing that I didn't mention in talking about the case was that Judge Talwani stated it is not uncommon for an expert retained to testify in a matter to have counsel or another consulting firm assist with the initial preparation and analysis that goes into an expert report. If counsel had done that here, do you think she still would have ruled that the expert pilot surveys must be produced?
Well, two things. There is a difference between drafting or editing of the expert's report, where it used to be pre-rule change that, every change was discoverable, which led to workarounds there, like, don't send me a draft. Let's share the computer screen and I'll tell you what, changes I would suggest you consider or whatever. So you don't have to play that game anymore. As to the pilot survey, Mary already correctly pointed out that it's not at all unusual to have a separate consulting expert do the pilot survey to get rid of any flaws in survey methodology, not share that result with the testifying expert, but use that information to guide the testifying expert in designing their study.
Yeah, and that definitely seems like something that they could have benefited from here. So great point, and a very interesting case about expert testimony and expert the documentation that goes with it. So I will move on to our next case. This one's a fun one. In this case, which was covered by Michael Berman on the EDRM blog, plaintiffs filed a motion for sanctions seeking issue and monetary sanctions against defendants, as well as an order appointing a neutral IT expert to image defendants' ESI devices in search for a responsive ESI, or alternatively compelling defendants to produce all responsive documents with an accompanying joint stipulation with supporting and opposing evidence. As California Magistrate Judge John Early stated, local civil rules 37.1 through 37.4 set forth the procedures for discovery motions in this court. Under LR 37.1, before filing any motion relating to discovery under Rules 26 through 37, federal rules, counsel for the parties must confer in a good faith effort to eliminate the necessity for hearing the motion or to eliminate as many of the disputes as possible. And plaintiffs claim they complied with LR 37.1 through 15 emails and 2 Zoom calls between counsel, counsel's provision in lieu of the Rule 37.1 letter, a draft copy of the completed joint stipulation 7 days before the final Zoom meeting occurred with all exhibits attached. They also advised that although their portion of the joint stipulation was submitted to the defendants before the final Zoom meeting as completed, they agreed not to serve the final version until after the meeting. Isn't that nice of them? However, in discussing plaintiff's motion, Judge Early stated, at that final March 28, 2025 Zoom meeting, I'm using air quotes as I read this, plaintiff's counsel directed strong profanity at counsel for defendants while meeting and conferring about the subjects of the motion. 2 of defendants' counsel submitted declarations attesting to the profanity by plaintiff's counsel directed to defendant's counsel, including the words effing, BS, and GD. Counsel also attests that plaintiff's counsel yelled at defendant's counsel and acted in an aggressive manner. One of defendant's counsel further attests that plaintiff's counsel issued threats to triple the settlement demand to make the suit impossible to settle if defendants refused to comply with plaintiff's counsel's demands, telling one of defendant's counsel, I'm going to try this case because of you. You pissed off the plaintiff's lawyer. You will pay for this. Side note, we say the P word a lot in this webinar, so I figure that one's okay. Plaintiff's counsel concedes he used profanity, but denies he used the specific profanity or threats alleged by defendant's counsel. Plaintiffs have violated both the letter and the spirit of LR 37.1 in connection with this motion. Judge Early also noted the initiating letter must briefly set forth the moving party's position. Here, plaintiff's portions of the joint stipulation are anything but brief. The more than 60 pages that make up plaintiff's portion is largely a rambling, often repetitive, at times disjointed presentation filled with accusations of a cover-up by defendants and or defendant's counsel. So Judge Early denied the motion for sanctions. So, Tom, a lot of lawyers seem to struggle with balancing advocating for their client and cooperating with counsel on issues like discovery. So, what do you recommend to our audience on how you can do both?
Well, we've had this discussion for ages now. Take a look at the Cooperation Proclamation from Sedona, or the Principles and Guidelines, especially from Sedona, especially the commentary to both of those commentaries that have sprung up since they were released, and you'll see a lot of discussion about this. That cooperation doesn't mean capitulation, and the phrase that we've heard an awful lot over the years, and I think all of us who've been doing this for a while, I've heard the phrase zealous representation, and so in checking a few things, I decided I'd look at the California bar rules and the Code of Professional Conduct, since this is a California case. I was actually quite surprised to find that in the last 18 months, 11 states have dropped demands for, quote, zealous advocacy from litigators in favor of milder definitions. And one of those was California. And so I dove even a little bit deeper and found a number of appellate court decisions over the last several years that have dealt with that issue of what is zealousness. And a lot of them quote, and this is just the one that I focused in on, In Re Marriage of Davenport, which is a California appellate decision. But the quote from the court, I think, is really on point. We close this discussion with a reminder to counsel that, and it says, all counsel, regardless of practice, regardless of age. I don't know why he singled out those of us who were older, but zealous advocacy does not equate with attack dog or scorched earth, nor does it mean lack of civility. Zeal and vigor in the representations of clients are commendable, but so are civility, courtesy, and cooperation. They are not mutually exclusive. Boy, if anything is, on point for this particular case, I think that's it. But it's also interesting that, states are zeroing in on this sort of behavior. The other states that have dropped zealous from their wording, state bars, Arizona, Indiana, Maine, Ohio, and Washington. But there's also been some big cases in other states, one in Florida, which was almost exactly on point with this. So zealousness, I think the quote was great. Zealousness does not equate with being an attack dog or scorching the earth.
A lot of great information there, Tom. You've sparked a blog post idea in my head, definitely to recap a lot of that information. That's terrific. And hey, I think, maybe they were trying to point to the younger, inexperienced lawyers for the age thing. But,
unfortunately, I'm sure Mary knows, we've gone back and we've seen this sort of behavior. I'm sure Judge Peck has also. We've seen this sort of behavior for a long, long time. And in some cases, it was considered acceptable. And so, unfortunately, I think perhaps in this case, we're learning from the younger generation.
Yep, indeed. Yeah, perhaps. So, Judge Peck, given that Judge Early referred to plaintiff's portions of the joint stipulation as largely a rambling, often repetitive, at times disjointed presentation, and so forth, when the local rules require brevity, and their strong profanity directed to defendant's counsel, should Judge Early have done anything more to address plaintiff counsel's behavior here?
Yes, I think monetary sanctions, even a small monetary sanction, would have been appropriate. And if really there was no financial harm to opposing counsel, could be a small donation, quote unquote, requirement to the court, or even just an official reprimand, whatever that really means, or, as some judges have done, require the offending party to take some ethics training, although forced ethics training, is it really worth it? Will the party actually learn from it, or sit in the back of the room reading the newspaper and fuming? But yeah, I think a little more could and probably should have been done. As to strong profanity, gosh dang it, that shouldn't occur.
Indeed. Yes. Yes. So definitely some decorum here. So, Mary, I'll look at the flip side. Should defendants pursue sanctions for the unprofessional behavior at plaintiff's counsel?
That's a good question, and it's always a judgment call. But I think the judge probably gave them an invitation to do that. I mean, some of the language, let's see, failure to comply here with the local rules was not a technical defect nor an oversight. Rather, it was an intentional tactical choice that sabotaged any chance for a good faith effort by both sides to attempt to resolve some or all of the issues. And he concludes with plaintiffs violated both the letter and spirit of the local rules, and those violations warrant denial of the motion. So it might, if they ask, they might get a sanction. But this might be enough for that particular situation, that the judge is already taken them to task with denying the motion itself with this kind of language.
Yeah, perhaps. I guess, we shall see if we get any more rulings on this case. Maybe we'll find out. In the meantime, I'll move on to our next case. And who says tar is dead? Here's our second dispute involving the use of tar in as many months. In it, the court on March 7, 2025, ordered Saris Regis to produce documents responsive to plaintiffs' RFPs using the August 30, 2024 search terms by March 28, 2025. The court cautioned that if Saris Regis failed to meet that deadline, it was to inform the court as to the percentage of documents that remain unproduced, why they have not been produced, and their anticipated date of production. Saris Regis didn't do any of that. Instead, it sought an extension to April 28, 2025 to finish conducting its document review and production, given the breadth of documents hitting on plaintiff's tar search terms, which the court permitted. When it missed that deadline as well, Saris Regis presented plaintiffs with 3 options for receiving its remaining documents. 1, produce more than 6 million documents that hit on the tar search terms. 2, produce the more than 3 million documents that hit on the August 30 search terms. Or 3, produce documents that the tar model has determined are likely responsive while sampling the remaining documents to confirm they are non-responsive. After plaintiffs took issue with all 3 of these proposals, contending that Saris Regis was disregarding its obligations in refusing to review its remaining documents for responsiveness, Tennessee District Judge Waverly Crenshaw stated, "It is evident that this is yet another attempt by Saris Regis to avoid complying with the court's orders. Saris Regis now seeks to impose its discovery obligations onto plaintiffs by forcing them to sift through millions of documents post-production that Saris Regis admits it has not reviewed for responsiveness. Under Rule 34, it is Saris Regis's obligation, not plaintiffs, to conduct the responsiveness review of its own documents to determine which it must produce. However, by Saris Regis disregarding common discovery protocol and practice by abjectly refusing to review for responsiveness here, it is apparent that such action is now necessary. And that was to order Saris Regis to continue to review documents per the TAR protocol, review for responsiveness rather than simply producing all search term hits, and complete its review and document production by Monday, June 9, 2025. Judge Crenshaw also warned that should Saris Regis continue to evade its obligations, sanctions could be in its future. So, Judge Peck, one of the options that Saris Regis offered was to produce documents that the TAR model has determined are likely responsive while sampling the remaining documents to confirm they are non-responsive. Isn't that what TAR is supposed to enable a party to do?
It depends on what TAR model they are using. Was it a TAR 1.0 model where after a limited amount of training, they considered the system locked there is a high probability in that case that it is not a very effective way of winnowing the data down. If it's a TAR 2.0, a continuous active learning approach, then yes, but that would have required a lot more work than just running, a computer algorithm with no input. So I think this is the classic answer of "it depends."
Mhm. All right. Well, let note at 49 past the hour, our first "it depends" of the webinar. So, I kind of thought this was interesting in that you could see that being a potential, but we don't know what power version they were using. So, Mary, do you think Judge Crenshaw would have been more amenable to the proposals by Saris Regis if they hadn't missed so many deadlines?
Oh, absolutely. I mean, the deadline misses is terrible. And then the other thing, this reminds me a bit of the Fannie Mae case. It was search terms back then, agreeing to search terms without understanding what the impact is. But I think there's some similarities with with this situation here. And if you don't have a good excuse, a good reason, a documented reason that you haven't missed your deadlines, you're not going to get the things that you ask for necessarily.
Yeah. Well, given that they're apparently expected to still, review millions of documents, even with TAR, definitely seems like they should have been better prepared for that. So Tom, go ahead.
Sorry, Doug. If nothing else, it means, you go to the court a little bit in advance of the deadline and you ask for mercy. Then you don't blow the deadline. Presumably it's the other side that brings it to the court's attention, and then you're in trouble.
Yeah, absolutely. Always better to ask for, let's see, in this case, permission than forgiveness. This is the one place where it's reversed. So, Tom, with the ability for technology to analyze so many documents today, could you see requesting parties accepting as many documents as possible in production so they can apply their technology to find even more documents that support their case? Or do you think they will they will strategically continue to expect producing parties to review and cull the documents in order to force a settlement?
Well, that's a great point, because when I'm working with receiving parties, as somebody who's technologically savvy and has the ability to make some of those decisions Judge Peck just talked about choosing what to use. As a general rule, I'd like to get my hands on as much data as I can. The flip side of that, of course, is you open yourselves up for a data dump, or in the case of like the BP case, you just have a monumental amount of data. But as a general rule, on a regular case, I'm willing to trust the ability to use the technology, and let the other side give me a lot of stuff, hoping that they didn't do a good job of searching through it, or they're going to, not want to do that and just pass it on. And as a bit of a strategy in negotiating to do that, I'll often say, we'll take more if you give us native files. I'm willing to take a little bit more data than I normally would if you'll give me native, because I have the ability to search and massage that much more. So
yeah,
it's a tightrope.
Yeah,
I mean, just supplementing what Tom said, it's sort of the strategy and cost issue. How much is it going to cost to review the greater amount of documents versus the benefit of getting more documents that you could use? Are you going to be finding a lot of junk that's going to make it hard to find anything useful, or is it possible that you'll be finding some hidden jewels? Remember, and this is the other thing, in most cases, plaintiffs are not getting paid by the hour. They're on a contingency basis where they only get reimbursed for their costs and they only get fees if they win. So it may not be in their interest to create more work for themselves.
Yep. It's definitely a tactical decision depending upon the case and your relationship with the other side. How much how much you can have that sort of a cooperative give and take with them.
Yeah, great points. And certainly one of the things that'll be interesting as the technology advances is, will you get to a point where that extra cost won't be so great, and maybe they'll just say, give me everything you can, and I'll deal with it. But I think we're
AI is going to solve all that for us, right?
Yeah, right. Exactly. There we go. All right. Our last case has a familiar theme, claims against former employees of an organization for trade secret, misappropriation, and more. In this case, defendant Rogers produced over 1,200 pages of text messages between Rogers and the co-defendants. However, plaintiff identified several deficiencies in Rogers' responses, including failure to produce any attachments to text messages, which was subsequently rectified, and failure to produce Microsoft Teams messages and emails from Rogers' Lochner, that's the company he moved to, email address, to or from clients, customers, or current or former employees of RIG. Plaintiff also sought permission to subpoena on Rogers' new company, Lochner, as well as an order directing Rogers to provide his iPhone, Lochner laptop, and Teams account to Counsel for RIG to be examined at Rogers' cost by an independent computer forensic firm chosen by RIG, which Pennsylvania District Judge Robert Colville denied without prejudice for now. Rogers' counsel had also responded to plaintiff's request for production by stating the request is overly broad and vague. On November 19, 2024, he also said that Rogers had had numerous communications with individuals that were customers and clients of RIG, communications with current and or former employees of RIG, and would gladly provide communications between certain individuals that the plaintiff requests, claiming that since Rogers was under no employment agreement with RIG, he was free to have these communications. But on December 31, 2024, he said, while Rogers has spoken truthfully about his experience at RIG, he is in possession of no responsive documentation and will again furnish the search results to plaintiff. Judge Colville stated, to be clear, Rogers' overbreadth and vagueness objections are overruled. The court has twice ordered Rogers to fully respond to outstanding discovery requests due to his failure to respond to discovery motions. The court will not disturb these orders. Rogers shall fully respond to request for production number 32, and any failure to comply with this memorandum order will result in attentive consideration of harsher sanctions than those provided for herein. In one breath, Rogers states that he should have been taken at his word that he possessed no responsive information, i.e., I did not possess any information responsive to the request, and I said so. Now that should have stopped the inquiry. In the next, he states that he searched a bit deeper and found 1,200 pages of responsive text messages. Again, Rogers must produce responsive information that is in his possession, custody, or control. His focus on the possession aspect of Rule 34 strikes the court as an attempt at clever gamesmanship. Based on the record before the court and Rogers' own statements, the court believes that it is not only possible, but likely that a search of Rogers' Lochner email and Teams account may result in a production similar to the text message production. At this juncture, it appears that Rogers has not even attempted to locate responsive emails, Teams messages to date. The same is, frankly, inexcusable in light of the court's prior orders. So Judge Colville ordered Rogers to produce the requested ESI, stating, Rogers proceeds at his own peril should he again assert that he has no responsive emails or messages in his possession, custody, or control, or should the court conclude that he has made an incomplete production respecting responsive emails or team messages in his possession, custody, or control. He also awarded fees and costs associated with the present motion and stated, counsel shall pay 50% of the imposed sanction. So, Mary, it seems Rogers' counsel said too much when stating Rogers had numerous communications with clients and employees of RIG, then followed that up with a declaration that he is in possession of no responsive documentation. How should that situation have been handled?
Well, I would think that they're the type of organization that could benefit from a consultant that knows eDiscovery inside and out. That can put a fresh set of eyes on the communications, because it was clearly an inconsistent communication. And it's very important that you document your good faith. And clearly, if the judge says, it appears Rogers has not even attempted to locate responsive emails, Teams messages to date, that's not where you want to be in a case like this.
Nope, that's for sure. Tom, despite the fact that Microsoft Teams is being used by a reported 280 million users, we haven't seen too many cases involving ESI from Teams yet. Why do you think that is?
Because nobody understands it.
Okay.
I talk to IT people about it, and they go, "Oh, Teams is just the bane of my existence." Look, it's a terribly technically complicated product. And so it's difficult for both sides, the requesting party and the producing party, to get a grasp on what's going on there. It's got decentralized data storage. There's not a single repository for all data. It requires different retention and disposition policies in various parts of Office 365. Workflows for handling teams are it's seemingly under constant revision. And of course, right now, Microsoft is changing, updating, slashing, whatever they want to call it, their handling of litigation holds and purview. That's all going to change by August of this year. It handles personal Teams accounts as opposed to corporate Teams accounts, private and shared channels, that handles all of them differently. There's deletion policies, so you can actually have automatic deletion built in if it's set up that way. You need to know about that. One commentator I was talking to about this wrote, you know, those threaded conversations in Gmail and Outlook that make it easy for you to understand the context of the emails in them? Yeah, that's not a thing in Teams data. So it's just difficult. So getting involved in disputes about it, you know, becomes even more difficult as people are trying to figure what the heck they got and how to get at it.
Yeah, absolutely. I kind of feel like Teams may be kind of the new mobile device. Oh, we're not gonna ask for it. We're gonna agree to avoid it because it's such a pain in the butt. Yeah. Although, as my friend Mary says, Teams has all the good stuff now, which I think she means a lot of the really good and important evidence is in Teams. So I would still think at some point we're going to see more cases involving Teams.
Oh yeah. I think you're going to see, you know, the front end of this. The data preservation front end, especially for corporate accounts, get more and more substance. And yeah, I think we'll get a handle on this in the next 12 to 18 months.
Yeah, I agree. So Judge Peck, would you have given Rogers another chance to produce emails and Teams messages if, like Judge Colville, you believe that he has not even attempted to locate them? Or would you have granted plaintiff's request for an examination of Rogers' iPhone, Lochner laptop, and Teams account?
If those are the only two choices, you know, another chance to produce or a forensic exam, I'd want to know at whose expense is the forensic exam going to be? Is plaintiff willing to pay for that in the first instance with the possibility of shifting those costs to Rogers? Then you know, what is the protocol going to be once a forensic exam is done? You know, you need a sort of taint team or a protocol that the relevant or potentially relevant material is given to Rogers' counsel, who doesn't seem to know what he's doing either, given to, you know, Rogers' counsel to deal with in the first instance before producing it to the other side. A lot of complexities with it. Can be done, you know, but so I think what Judge Colville did was the better choice here. It's, you know, it's sort of giving Rogers enough rope to hang himself. The next step, if there's still a failure to do a good faith review and collection review production, you know, we may then be at the default judgment stage. So in a way that is simpler. So I think that is what I would have done, just what Judge Colville did.
Yeah, definitely did seem like giving him one more chance and making it very strong. What that entails is certainly a good way to kind of, you know, make it the last chance for sure. A comment back on the previous case, just noting that even if TAR 2.0 was used, they may have written their TAR protocol as all documents above the cutoff must still be reviewed by a human. While producing all documents above the cutoff without review and sampling below the cutoff population is certainly an acceptable use case for TAR, it highly depends on how the TAR protocol was written and what they agreed to, and if they're now trying to get out of the agreed upon protocol. Great point, and we don't know exactly what the protocol said. Certainly, I have a feeling had we had Sarah's Regis realize they were talking about millions of documents potentially to be reviewed. I think they might have tried to push for a little bit of a different protocol, which is certainly important to kind of understand. So yeah, absolutely, great point. So now for the contacts page, and as Kaylee mentioned at the outset, we do have a date for our next webinar, which is almost a full 6 weeks away on Tuesday, August 5th. And we promise we'll try to limit the strong profanity in that one. So, so with that, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we thank you for anchoring, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it, show the Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love, and find your emojis at the bottom of your console. To be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Thanks, everyone.
Bye all. Stay cool.